I'm very proud to moderate this panel for a couple of reasons. In part because I have both new and old friends on this panel, but I have all friends on this panel, and I think that's a terrific thing to be able to do, is to stand with friends and have a good conversation. And what this panel does, I think, is it truly demonstrates that the U.S. Asia Law Institute is the U.S. Asia Law Institute, right? It takes a broad look at issues around Asia. And with Asians from various locales. We have, I'm proud to say, because the focus of the panel is on the East China Sea, that I'm proud to say that we have representatives of each of the 4 locations that border the East China Sea, whose peoples historically have connections to the East China Sea, to the cultural connections, resource connections, trading connections, political connections, and in some cases to the small islands that are known as the Senkaku or the Diaoyu or the Diaoyutai, at the center of this crossroads of East Asia. Each one of these people, each one of these generous gentlemen is also participating in the U.S. Asia Law Institute's case studies. So I'm grateful to them for that as well. And we may begin to hear some of their insights today from their case studies. But really the focus of this panel then is bringing these ideas about how do we resolve some of the real tense issues, and how might some of those resolutions be brought about by support from international litigation or arbitration. And so I do want to point out one story. It's a story Jerry likes to tell, so I'll repeat it. And that's the story that before the previous administration left office, Foreign Minister Gemba wrote an editorial. I don't recall where it was published. Maybe Wall Street Journal, I don't recall. The Herald Tribune. And basically, looking at this particular dispute and asking the question, well, one of the options is we could litigate these issues. Japan has opened its jurisdiction at the International Court of Justice and could, in fact, if China were willing to bring the case, could in fact litigate the issue over the Senkaku Diaoyu Islands. I know some don't like to call it a dispute, so I'll refrain from that. But the idea is that that litigation could be a supporting element. It could be a supporting element. And I'm looking forward to each of these distinguished panel members to help us to understand how it might be a supporting element in their views. So up first, I'm proud to say, is Zhang Xinjun, a longtime friend and professor at Tsinghua University School of Law in Beijing. Thank you, Xinjun.
Thank you, Peter. Also thank Jerry for inviting me here. Great honor. My topic today, as you can see the title, this is Diaoyu Senkaku Island dispute, shelving, denying, or settlement. Let me just get started for those who are not very much familiar with the situation in between the two countries. I started to mention the 2008 principal consensus. In my view, it's a product driven by goodwill from very high level of political decision making. But in the meantime, that's a misfortune that create a very stubborn, stiffened position, especially on the side of the Japanese government, saying that there exists no dispute over the Diaoyu Senkaku Island. And that create, to some extent, difficulties when we think about any kind of mechanism for the settlement of the dispute. So I started from here. Actually, I can show you first the map. I will show the map, and in the meantime, I will describe the happenings in the time stream. So here you can see this S1 and S2. I actually divided this, particularly important even in the later discussion on the dispute settlement, the S1 is somewhere in between the 30 parallel out latitude, the north latitude, and S2 is in between 27 to 25. And you can see this island, Diaoyu Senkaku Island, that is approximately located in the mid of S2. Now, that consensus of 2008 that has been talked from 2004 to 2008. It's about 11 rounds of talks. In the fourth round, the Chinese government proposed to include the S2 area, Diaoyu Senkaku dispute, into the negotiation. But the Japanese government rejected this proposal. That led to obvious stalking of there's no substantive development in the restaurants of the dispute until it comes to exchange of visits between the leaders of the two countries, and under a very, I would say, a very strong political determination, the two countries finally decided to issue concurrently the 2008 principled consensus, in which actually the S2 area is not included as any part of arrangement. So most of the arrangement down in the 2008 consensus is within the S1 area. So one is but actually the result is that the Japanese rejected the proposal to include Diaoyu Senkaku, and then it seems that China has to take it, and the result is that there's no touching of the Diaoyu Senkaku Island in the 2008 consensus. Well, my view is no touching of that dispute at all in the consensus, I think, is indeed flexible to both the Chinese position as well as the Japanese position. The Chinese position, the Chinese can explain that both sides agree to shelve the dispute, but the Japanese position would be there's no dispute at all. But if you look at the history of the happenings in this negotiation, you will find that flexibility disappear if the Japanese consider that their rejection and non-inclusion of Diaoyu Senkaku Island in the consensus is a winning point for the Japanese side. Actually, that, in my view, led to the kind of acceleration of the tit-for-tat in between the two countries. And especially, I mentioned two instances. One is the arrest of Chinese fishing vessels who doing fishing in the territory sea of the disputed island. That is 2010. And the other is the so-called nationalization of the disputed island, which was taken by the Chinese as something that Japan will go to the opposite position to what the Chinese think there has been a consensus agreement of shelving the dispute. So you can see clearly the two governments respectively issued their second round of statements. The Chinese state in 2012, after the first statement on the Diaoyu Senkaku Island that the Chinese government did in 1971, and the Japanese did in the second statement on the Diaoyu Senkaku issues. On 2013, that is the second one after the first one done in 1972. And you can see clearly in the Japanese 2013 basic view saying they add something which does not appear in the 1972 statement, saying that there exists it's clearly said there exists no issue of territorial sovereignty to be resolved concerning the Senkaku Islands. So now the problem is that you can find that such huge differences between the two views of the countries. One is suggesting that we have a dispute and we shelving it, and the other is that there is no dispute. So this is shelving as denying, and then you have to find a solution, a settlement. How can you do that? So first we look at ICJ. We know that Japan had already made a declaration under ICJ Statute 36, paragraph 2, the so-called optional jurisdiction. Although Japan made some reservation later after Japan actually lost the Wheeling case. But as it may, I don't think that make much sense with regard to the submission of the Diaoyu Senkaku Island issues or dispute to the ICJ, because China never did accept such optional jurisdiction. In conclusion, I just quote Judge Rosalind Higgins when he talked about this, the similar problem. She concluded that in summary, I think it's unlikely in the extreme that any of these disputes will come to the International Court of Justice. So what about other forums? It is very clear that this territorial dispute cannot be submitted to any arbitration or adjudication process under the UNCLOS, Section 15, Part 15, Section 2. Because although I know that in the past case there's a lot of arguments that not all territorial issues has been put outside this mechanism, but at least to this typical territorial dispute, I don't think there's any space to interpret that this kind of dispute will fall into subject matter jurisdiction of the UNCLOS dispute settlement mechanism. What about special agreement, or if we can do under the principle, the root of forum prorogatum? What about that? So first we have to look at the Chinese position. Fortunately, after South China Sea arbitration, China still stay in the UNCLOS. That is something different from the United States. Actually, I had some different views with presentators in the last panel, but unfortunately we don't have a Q&A session. I would say that maybe we can look at if we talk about the enforcement of the rule of law, maybe we can talk about the recent case in between U.S. and Iran and U.S. Palestine. In the U.S.-Iran case, actually, there has been the order for provisional measures, which is also, according to the court, binding. And it's curious to me to look at what the US will respond according to the rule of law. What I want to say that China, in the bad or good or bad sense, we learn too much from the United States. So we'll look at the Chinese stance. It's very interesting. You see that in the adversarial opinion pending in ICJ, that the Chinese government is the second time the Chinese government submitted a written statement. But it must be something on purpose. So which I quote in paragraph 15 saying that the jurisdiction of any international dispute settlement mechanism over dispute between states depends on the prior consent of the parties to the dispute. So in that sense, I guess it is very unlikely that China will unilaterally submit a dispute against Japan over the territory of Diaoyu Senkaku. So that makes less likely for some of the commentators saying that Japan, although did not recognize the existence of dispute and therefore will not actively work on it, will not unilaterally submit the case, but Japan will rather wait for China to submit. That will make that scenario less likely. So what about special agreement? I just put a question mark, and I will leave it to the floors in the Q&A. So what about settlement and dispute settlement and the delimitation dispute and pre-delimitation dispute? We, of course, very well know the Chinese 2006 declaration made under Article 298. I think for those who are familiar with this clause, and that is actually give rise also to the jurisdictional issues, objections in the South China Sea case, which in my view that tribunal did not actually fully address this objection. So to the delimitation dispute, I would say that it's not possible for any submission to adjudication or arbitration under the UNCLOS because China's Article 298 declaration excluded such disputes from the compulsory judicial process. What about the partial submission to the compulsory conciliation? I will say partial submission because if you submit the ACE2 area, if you remember the picture, that will somehow necessarily involve the concurrent consideration of any unsettled dispute concerning sovereignty. And therefore, that will be not only excluded from the compulsory judicial proceedings, but also the compulsory conciliation proceedings. And also, it is technically difficult for such a partial submission. It may damage the Japanese position that there is no territory dispute at all throughout the East China Sea. So if you want to make a distinction between what is necessarily involved is disputed, what is not, then it implies that you recognize this. That will damage the Japanese position. What about the pre-delimitation dispute? What I want to say is actually the disputes concerning interpretation or application of Article 83, paragraph 3, or Article 74, paragraph 3. Actually, we can see that the Japanese ruling party actually made some proposal to submit this kind of dispute to a judicial or international arbitration. Is it possible for the Japanese to do like that? It seems that there's no technical or legal obstacles for Japan to submit this this kind of dispute, because this dispute occurred in S1, north to parallel of latitude 27 degree. So far from the Diaoyu Senkaku Islands. The real problem is which compulsory proceeding that such disputes may be submitted if consider China has already made the declaration under Article 298. Japan may consider submission of this pre-delimitation dispute to an Annex 7 arbitration if it believes that they are not disputes concerning maritime delimitation. That is actually what the special chamber decided in the Ghana Carter David case, and therefore not falling into the exclusion under Article 298. That is what the tribunal did in South China Sea Act. However, Japan may think twice if we consider the latest decision on competence by the compulsory conciliation commission in the Timor-Leste and Australia case. In that case, the Commission firmly holds that it has jurisdiction on the question of Article 83, Paragraph 3. This decision can only be made by interpreting Article 298 to the extent that such a question does not fall into the exclusion from the judicial arbitral proceedings. This interpretation is the direct answer to the jurisdiction question in application of Article 83, Paragraph 3, as to which compulsory venue it shall be subjected to under Article 298. And I would say this interpretation, even made by a conciliation commission, that is by no means less authoritative, given the fact that the commission has the power to determine its competence by interpreting this Article 298, and its decision on competence is binding on parties. I just finished here. Thank you for your attention.
Well, we'll go according to the program, and so our next speaker will be Professor Song-Yen Hui, and we hope we can hear why things might be possible from Song-Yen Hui, and we look forward to your thoughts.
Which one was yours? The PowerPoint? This one here? And then to go forward.
Well, thank you very much. Professor Cohen told me that I have to speak loud. If I speak too loud, please remind me. Thank you, Jerry, and thank you, Peter, for this kind invitation. And I'm trying to respond to the question raised by our chair. Is there a role for international tribunals in this dispute? In my opinion, the Senkaku Diaoyu issue, problem, deadlock, dilemma, includes a number of maritime disputes in the East China Sea, including territorial sovereignty, maritime boundary delimitation, in particular EEZ and continental shelf, baseline claim, legal status of marine futures, and the right to generate maritime zones. Last one, oil and gas exploitation and exploration in the disputed areas before maritime boundary delimitation agreement is concluded. So this is the definition I gave when I was doing the research to examine the existing maritime dispute in the world. And this is a definition about maritime dispute. It's a disagreement on the point of a law or fact, a conflict of legal views or interests between two or more states that is related to territorial sovereignty over inhabited or uninhabited islands, or is involved with overlapping entitlements to rights and jurisdiction in different maritime zones, such as territorial sea, contiguous zones, easy continental shelf, high sea, and so on, in terms of uses of the ocean space and exploration and exploitation of its resources, both living and non-living. So when I studied that, examined those cases, there are over 400 maritime disputes in the world. Less than half have been resolved. Two main causes for maritime disputes. The first one, sovereignty disputes over land features. The second one is overlapping or disputed maritime zone in those entitlement rights and so on. But it's more likely for the maritime disputes to be settled if the method of arbitration or judicial settlement is employed by the party to that dispute. Two cases in the Southeast Asia involving Malaysia and Singapore. And the first one's ATLAS arbitration. The two countries submitted disputes to ATLAS for settlement. And the dispute was settled. And this case about land reclamation by Singapore in and around the Strait of Johor. So that's done in 2003. The other one, judicial settlement, ICJ case. We know that over the sovereignty over the three disputed islands in the Strait of Singapore, Pedra Branca, Palau Batu Puteh, Middle Rock, and South Ledge. And that was decided in 2008. Judgment was issued in 2008. Although the government of Malaysia tried to argue against the judgment, but then later on it was withdrawn. So what less we can learn from this kind of global experience with maritime disputes, the reason for success, good relationships between the parties to the disputes. The second one, states are law in the disputed area, no strategic importance, existence of political will. Efforts are made for negotiation, are willing to cooperate, high interest in the development of resources, no third party involved, reaching agreement, either provisional or final, and last one, no opposition against the legal approach. Jerry, because I have to speak loud, also fast, because I only have 11 minutes now. Failure. Again, a number of reasons. One of the important reasons in our region is the lack of political will. And the other one will be the intervention from the third party. For example, the United States, if in that process try to intervene, maybe want to play the role as a mediator, maybe once is good or bad. So there are other reasons, maybe sovereignty concern, that's the most important things. So this is a dispute in the East China Sea. Japan, we know that the position, no dispute, right? And this is the position from Japan. And China said this is Diaoyutai Island or Senkaku Islands have been inherent territory of China. And those are the different views. But Japan has that kind of experience going to the court. It lost ICJ. Now, if the dispute between Japan and Russia Federation regarding fishing vessel being arrested, crown release cases before the ITLOS. And then the ICJ, the Whaling case, we know that. What about China? China, as this morning we heard about the possibility for China to submit a dispute to international tribunal or courts, WTO, as October this year. China as a complainant of 2020 WTO cases. as a respondent, around 43 cases. So we are seeing that trend of development that China is going to do that, given the fact that if China calculates that the benefits is higher than costs, the chance to win. If the Japanese government's position is that no such possibility for China to win the case, how should China consider to submit that case to that international adjudication process? So is there a role, in my personal opinion, for this kind of dispute between China and Japan to be submitted to judicial settlement? I think right now, at this stage, unlikely, very, very difficult. So, but we have to know that both Japan and China are members of the United Nations, are also party to the UNCLOS. So under Article 279 of the Law of the Convention, under Article 33 of the UN Charter, and other, they are obligated. Article 283, they should negotiate, exchange views, right? Article 74, Article 83 of the Law of the Convention, they have the duty to make effort to cooperate regarding delimitation. If they cannot reach the agreement, they should consider the possibility of adopting, for making a provisional arrangement, right? And in addition to those international treaty, there are also bilateral agreement between Japan and China, right? 1972 joint communique, 1978 treaty, 1998 joint declaration, a number of them. So there are a number of methods under the UN Charter, and they are obligated, they have to settle dispute according to this peaceful means. But in my personal opinion, if a balance of national interests could be struck in Chinese Baiping, two parties, two countries are able to strike a balance in terms of national interest, sovereignty, national pride, nationalism, national honor, that kind of things. It's possible. It's likely to see this kind of peaceful means to be employed by two parties. But now there are a number of potential disputes or issues which can be settled by the international tribunals or courts. The first one is maritime boundary delimitation, because the dispute between the two countries, natural prolongation of land territory versus median line. The second one, baseline claim, the use of the method of straight baseline by China in the South China Sea. And the legal status, I have 5 minutes, so the map showing the outer continental shelf claimed by China. In this case, the government of Japan recognized the dispute. There is a dispute between Japan and China regarding outer limit of continental shelf. So that's a dispute. The second one is the straight baseline used by China in 2012. That's about the Senkaku Diaoyutai Islands. And this is the one, the legal status of marine features in the East China Seas. We see a number of rocks, smaller, very small, tiny, and uninhabited. Are they allowed to generate 200 nautical miles easy or continental shelf? And I agree with Mr. Paul Reichler that if we are able to settle that dispute, we can ask the two parties to reduce tension and then in the East China Sea. I think that's the good way to do that. And this is the one regarding the siphon effect. We know that in East China Sea, China is developing oil, but it's in the western side of the median line. But the Japanese government argued that it is against the principle of equity because the siphon effect, you are going to exploit all oil underwater continental shelf. So it's not fair. So there are difficulties, but in my personal opinion, the best approach is diplomatic negotiation. So through negotiation, both parties will discuss and clarify the legal issues and find a way for compromise. So there are a number of examples of existing agreement or arrangement. 1974, Republic of Korea, Japan, they have that agreement, right? Even today, still ongoing, that treaty. And there are other, Professor Zhang Xunjin mentioned about 2008, the principal consensus. And then 2013, Taiwan and Japan reached agreement to settle dispute, put aside the dispute in the 200 overlapping 200 nautical mile exists surrounding Senkaku Island, Diaoyutai Island, and they want joint management of the resources in that region. So there are others. So this is the negotiation between Japan and China. 11 rounds of talks. Official government talk about the possibility, joint development, settle the disputes, and they have that principled consensus. And then right now we are seeing the 9 rounds of China-Japan high-level consultation on maritime affairs. And the 10th round is going to be held maybe this month, next month, the second half of this year. And they reached a number of important things, agreements, the area maritime communication mechanism, and so on. So this is the thing I just mentioned that in June this year, the maritime and area communication mechanism entered into force. And the following are my personal policy recommendations. I think I will be able to finish maybe within 2 or 3 minutes. The first one is to enter into further negotiation based upon the 2008 China-Japan principled consensus on East China Sea. And this is very important because both countries accept the common policy goal to make the East China Sea a sea of peace, friendship, cooperation. And they are willing to jointly develop oil and gas in that disputed waters. So the second one, maybe China and Japan can conclude a multilateral fisheries management by including Taiwan and Korea in this kind of a regional fisheries management conservation organization. It's a sub-regional organization, and we have the example right here. So the next one is reaching a new understanding, because in 1972, 1978, both China and Japan said that we have the agreement, we have the understanding, we put aside the dispute. But 2010, since then until today, it's Japanese government's position, no such understanding. They are not going to shelve the disputes. That is going to affect the further negotiation. So 2006, at that time, Prime Minister Abe again said that they agreed to turn the East China Sea into peace of friendship, cooperation, and peace. They are going to adhere to negotiation and dialogue and put aside dispute and pursue joint development. Not long ago, last month, October 25th to 26th, Prime Minister Abe and President Xi Jinping and Premier Li Keqiang, they met in Beijing, also making this same policy goal to make East China Sea a sea peace, cooperation, and friendship. So there are other peaceful means. The final slide include setting up an informal workshop on managing potential conflict in the East China Sea. Code of conduct from South China Sea workshop have that document. It failed, so it turned into DOC, Declaration on Conduct. And right now, Chinese government said that within 3 years, they are going to adopt the Code of Conduct. What if we have that kind of informal workshop in the East China Sea? And then maybe not necessarily the COC so quick, maybe DOC. And second one, considering the need to adopt a bilateral original Code of Conduct. That's what I'm saying that. And third one, is it possible to set up an eminent group of experts to discuss the issue related to respective sovereignty claims such as historical records, evidence, maps, official correspondence, law enforcement activities, effectivities, and so on. Finally, holding more track 1, track 1.5, or track 2 meetings or conferences in relation to the Senkaku Diaoyutai issue, problem, deadlock, conflict, whatever. Thank you very much for your attention. Thank you.
Now we get to hear from Professor Sioku Lee from Inha University and the perspective of South Korea, which doesn't have a territorial claim, but certainly has interests in the East China Sea.
Now I suddenly realized that why I have to speak between two parties. Good afternoon, everyone. First of all, let me express my special thanks to the organizer to invite me to be part of this program. Here, my special thanks to go to Professor Cohen, who taught me 20 years ago here at NYU. It's my special pleasure to back to the school I studied. Today, I'm going to talk in a session of the Diaoyuta Senkaku Island dilemma, and they're looking for the role of the international tribunals. My previous two speakers already touched upon the couple of the issues related with the ICJ, the jurisdiction issues. I'm going to talk about the other issues, for example, judgment of the ITLUS, International Tribunal of the Sea, and the implication of this jurisprudence and the maritime order in Northeast Asia, in particular related to the Senkaku Diaoyuta issues. If you look at the map here, as Dr. Song mentioned about a couple of the arrangements, from the Korean perspective, with the very limited area, Korea-Japan, they don't have any quite extensive fixed maritime boundary, so that instability in Northeast Asia largely rely on the instability from the ocean. In particular, the states in Northeast Asia, like Korea, which highly rely on the seaborne trade, which 98% of the whole trade come from the ocean, it's very much important to keep the stability of the ocean, the security and safety. The role of the International Tribunal of the Sea is very much important. When it began its business in 1996, and so far, there are 25 cases referred to the tribunal. And 2 among the 25 cases are discontinued, and 1 is still pending, so that the tribunal just entertained 22 cases. Among the 25 cases, 16 are urgent proceedings, 9 are the prompt release case, and the 7 are provisional measures, and they enjoy the 7 contentious cases and 2 advisory opinion. And among the jurisprudence and among the contributions, the ITLUS contribute to the development of international law, in particular law of the sea. We can classify largely 4 areas. The first, the prompt release. Unfortunately, based on the 9 cases, the last 2 cases are actually Japan's initiation against Russia, Hoshimaru and Tomimaru. And there is no more cases referred to tribunal. But 9 cases from the tribunal, I believe that they established a couple of the jurisprudence to us. For example, what is the amount size of the bonds, and the ship as a single unit, and the humanitarian perspective in terms of the crews who are in detention. So that prompt release case from the tribunal is very much important for us to keep the maritime order. When you're talking about the maritime order, we are usually talking about hardcore, like a sovereignty or the maritime delimitation, but there are other important issues we have to take care. The other issues, other area the tribunal contributes for the development, I have to say that the part 12 of the UNCLOS, which is the protection preservation of the marine environment. Although there is no black letters in the convention, the tribunal very much elaborates a couple of the principles, for example, the precautionary principle and the duty to cooperate. and also the responsibility to conduct to EIA, the Environmental Impact Assessment. Those are very much important indeed, and largely touch upon the various issues, international environment law and the law of this area. And the other two issues which I point out, I believe that is very much important, the decisions laid by the tribunal. One is about the advisory opinion requested by the International Civil Authority. The advisory opinion is, in fact, about the obligation responsibility of the state sponsoring its nationals conduct the activities in the area, and which is very much important for us because one of the judgment is a request the state parties to take the domestic measures. And although from the perspective of the international law, the advisory opinion do not have the definite binding force, but after that, the advisory opinion state parties to take domestic legislation because that domestic legislation has been the factor when international civil authority take a consideration in terms of the decision-making process. Korea indeed one of them. Based on that, the advisory opinion, we make a domestic legislation in terms of the deep seabed mining activities. And the one is today we a bit talking about these issues. The last contribution from the tribunal, and all the judges are very delighted to see that is the maritime delimitation. To 2013, the tribunal provide the judgment in terms of the Bay of Bengal case between Bangladesh and Myanmar. These cases is a couple of the numbers of the first. This is the first, the maritime delimitation report to the tribunal from Asia. And this is the first case decided to go beyond 200 nautical miles in terms of the continental shelf. And also the tribunal invented a very interesting terminology of the gray area. And but from my own perspective, why this case is so important is that because it followed from the previous cases decided by the other courts, International Court of Justice. For example, the Black Sea cases, we pretty much refer when you apply to the basic methodology in terms of the maritime delimitation. We usually call that so-called the three-stage approach. And from that, the Black Sea cases and these those cases follow. And the imminent cases from the ICJ in the Nicaragua, Colombia also follow the very similar steps, so that it relieved some of the concerns in terms of the fragmentation of the judicial settlement in terms of the maritime delimitation. So from my point of view, I believe that this the judgment is a very much important decision so far. As you may know, that the December 2015 is the last case, is a report to the tribunal, which is the MV Nostar case, still is pending. And over the last 3 years, there is no case to the tribunal. I don't know why, and the judges also, the tribunal very much wanting to have a case, I believe. But there is something we have to think about, because there is some implication of the judicial settlement mechanism of the tribunal, and also the convention. So in terms of the area of the contribution of the tribunal, throughout the 25 the cases referred to the tribunal, I must say that there is a very much important contribution in terms of the marine environment and also law enforcement in relation to the prompt release and also the maritime delimitation. If we apply the contribution to the issues of the Senkaku Island issues, as already previous speakers touched upon the quite complicated issues, but this is a never-ending story in Northeast Asia. If there is a dispute area, so-called, and if the counterparts to engage or to conduct the provoking the various means that indicate that there should be some dispute that should be resolved. And then the South China Sea arbitration depends on where you are, what kind of stance you have. there should be different understanding and interpretation about these judgments. I have to see that whether state practice really follow this judgment in the future, but in particular including the interpretation of the Article 121 of 3, the status of the island features of the South China Sea, and also the other issues. But I pretty much enjoyed that the judgment, in particular law enforcement aspects, in particular the fishing activities of the other state parties, and also the protection preservation of the marine environment. Together with the contribution of the tribunal, which I mentioned that these arbitration decisions will significantly influence for the cases we have in Northeast Asia. Let me briefly touch about the aspect of these Senkaku issues. At the time that Peter talking about the case report, he talking about the Eritrea-Yemen case. If I recall correctly, one of the issues of the Eritrea-Yemen case is Article 16 of the Treaty of Lausanne of the 1923, which is a peace treaty of Italy. And that is an indication of the blanket renunciation, or the in legal term of the erga omnes effect of the territorial disposition. And if you look at the San Francisco Peace Treaty, Article 2B is about the Senkaku Island. And if you look at the San Francisco Peace Treaty, there is no Chinese name, and there is no Japanese name about these features, and also there is no international names. This is a blanket renunciation. The articles say that just Japan, give up all rights and title and claims against the Formosa, which is Taiwan, and Pescatore. So there is no indication of where this island should go, which is in fact, if you look at the drafting history of the San Francisco Peace Treaty, you have to understand that this is based on the intention of the drafters. So they left those features, do not give anyone of that the state parties. And if you interpret the Article 2 together with the Article 3 of the San Francisco Peace Treaty, where the features, the area is belonging to the UN trustee with the United States, the administrative authority, which means that it goes together with where this island originally came from when 1894-5, at the end of the conclusion of the Sino-Japanese War, in terms of the Shimonoseki Treaty, where this island originally came from. The reason I mentioned to this San Francisco Peace Treaty a little bit length, because all the territorial issues in Northeast Asia derive from this legacy of this post World War II arrangement. So that whether we can approach these issues without touching upon the sovereignty or maritime delimitation, I don't quite negative to see that how we address these issues. So that if you look at the right side of the map, which is the Japanese, maritime, the area, they indicate that it is quite a fragile, the area we can understand. So, but this is not the only cases happen to between China and Japan. Although I'm very comfortable to talk about the cases, which is Korea is not a party. But exactly, if you look at the case in reverse way, this is exactly the same things happen Korea and Japan. We do have island issues. We do not use the term of disputes. We say that the island issues in a correct term. And I know that the Senkaku disputes, but we don't have any dispute at all. And the thing is that, which I mentioned about the cap of the judgment from the tribunal and the recent arbitration decisions, I think the good way, they work very much in our region. For example, the government won't build 2011 as the Ocean Research Center within the territorial sea of the Dokdo, which is Takeshima, Japan's term. But within the discussions inside the government, they decided not to build in there. You know, there is some criticism inside the government because that limitation of the exercise of the sovereign rights, and you know, the people in Korea cannot understand why government is served to restrain to exercise their sovereignty or sovereign rights. But as I mentioned, the couple of judgments which I mentioned that I think they impact in good way to the government of Korea, because the government does not want to provoke our neighboring states, which has some of the indication of the issues. So that still, I think the current status quo was maintained in good order, and that will be, I think, one of the good aspects of how the judgment or jurisprudence of the international judicial bodies influence over a couple of issues we have in Northeast Asia. So in conclusion, as I mentioned, there are 25 cases to the tribunal, and a couple of the arbitral decisions we have. And we know that there is some issues between China and Taiwan and Japan over the Senkaku Diaoyutai issues. I don't think the sovereignty, you know, although the 25 cases are all important, but if you look at the gravity of the importance of the cases, you have to understand that if the sovereignty or the maritime delimitation involved, I don't think it is work out well. Previous speakers also the morning session talking about some of the sensitivity of the sovereignty issues of territorial disputes or territorial issues in Northeast Asia, because all territorial issues related with the post-World War arrangements, which directly in fact to the colonial legacy in Northeast Asia. So all issues related with that from the Korean point of view. So without clarifying what kinds of nature we have in this region, it is very much premature to discuss the sovereignty issues. However, as I mentioned, the two issues, law enforcement and also the marine environment, are very much important. I believe there is a player at a high degree when we approach the maritime issues in Northeast Asia. So I'm going to stop here. Thank you.
Our next speaker is Professor Kentaro Nishimoto from Tohoku University School of Law. And while we're calling up that PowerPoint presentation, I want to make two comments. The first is I was quite impressed. I'm not sure I followed all your points, Sioku, on the Turkey's renunciation of sovereignty in the Eritrea Yemen case and how that might apply to the East China Sea. So be thinking about it, because I'm going to come back with a question to you on that issue, and maybe you can explain in a little bit more detail how that relates to the Senkaku Diaoyu dispute. The second thing I would like to say is I'm really sympathetic and impressed, frankly, in the panel members' ability to handle themselves after flying 14 hours yesterday and being 12 hours out of your time zone, which means that you're about waking up now in the morning. I don't know, maybe that's about it. And above all, dealing with these kinds of complex issues in your second language and dealing with them so ably. I'm really impressed, and I want to thank you all for that before we get too far along. So, Kentaro, over to you.
Thank you. First of all, I would like to take this opportunity to thank the organizers of this conference, and especially Professor Cohen, for giving me the opportunity to be here and to participate in the conversations. For my comments, I would like to address the possible role of international tribunals on three issues related to the Senkaku or Diaoyu Islands. So I would like to stick to the topic of this panel. I would like to first address the question of sovereignty over the islands, and the second is the current situation in the territorial sea around the islands, and the third is the broader issue of managing the issues in the East China Sea. And on the first issue concerning sovereignty over the islands, I find it very difficult to see any direct role for international tribunals. And I am happy to see that from this panel, I think a sort of agreement is emerging that probably this is the case, and we see some agreement on a very disagreeable topic. And on the first hand, China takes the view that disputes concerning territorial sovereignty and maritime delimitation should be resolved through negotiations. And this general position was clearly laid out in relation to the South China Sea arbitration in its position paper, and similar views have been expressed in the context of the Senkaku Diaoyu Islands as well. On the other hand, as you have been learning from the previous presentation, Japan takes the position that there exists no issue of territorial sovereignty to be resolved concerning the Senkaku Islands. And although this position, I think you have to realize that this position is intertwined with the merits of the issue, and it's not a statement regarding any possible jurisdiction of an international tribunal. The statement does imply that from the viewpoint of Japan, if there is to be a case concerning the Senkaku Islands before an international tribunal, the initiative would have to come from China. So I think that is what the statement would imply. And so therefore, for different reasons, both Japan and China are not willing to solve the dispute through third-party dispute settlement mechanism. And in discussing a possible role for an international tribunal, and I think this was mentioned at the beginning of this panel, reference is often made to Japan's declaration recognizing the jurisdiction of the International Court of Justice as compulsory under the optional clause of the statute of the ICJ. And it is sometimes argued that China had always been in a position to bring a case if it had made a similar declaration, and if it had made a similar commitment to the rule of law in international society. And although it is quite unrealistic in reality to expect China to make this declaration in any time in the near future, such arguments raise interesting issues concerning Japan's declaration, which recognizes the jurisdiction of the ICJ as compulsory. And if you could look at the text, over all disputes arising on and after 15 September 1958, with regard to situations or facts subsequent to the same date and not being settled by other means of peaceful settlement. And this uses something that is referred to as a Belgian formula, which limits the jurisdiction rationale temporis of the ICJ. And I think, well, this does raise a number of issues concerning whether, in reality, the Senkaku Diaoyu Islands sovereignty dispute could be brought to the ICJ, even if China makes an optional declaration. But I think the full discussion of this issue will take a little bit more than 15 minutes. So in the interest of time, I would like to confine myself to just point out that there may be different views on the applicability of the Japan's optional declaration to the issue of sovereignty. The second issue is the situation that has emerged after September 2012, where Chinese law enforcement vessels are routinely present in the territorial sea around the islands and are countered by Japan Coast Guard vessels, requiring them to leave the territorial waters. And this has led to concerns about unintended accidents and escalation of conflict. And in this regard, international tribunals may have a role to play in clarifying the law that apply to the operation of law enforcement vessels. And one of the parties may be able to unilaterally refer a case to an international tribunal using the dispute settlement procedure in Part 15 of UNCLOS. I don't know if this idea would be feasible in practice, but in the interest of sort of identifying the full range of options we have in this regard, I would like to explore such possibilities. And one such possibility is to frame the dispute as one relating to rules that apply regardless of the sovereignty over the islands. A dispute concerning, for example, a violation of the 1972 Convention on the International Regulations for Preventive Collisions at Sea, or COREX, it may be such an example. And if you could recall, in the South China Sea arbitration, the Philippines succeeded in its claim that China had operated its law enforcement vessels in a dangerous manner in the waters near Scarborough Shoal. The tribunal in that case considered that such a submission reflected a dispute concerning Article 94 of UNCLOS, which applies to all maritime zones, including the territorial sea. And if such a case was possible, this may be helpful in establishing common understandings on the legal limits concerning the operation of law enforcement vessels, although at the present, there seems to be a stable status quo in practice. Another possible way would be to frame the dispute in a way so that a tribunal is persuaded that even if it has implications for sovereignty, the dispute is a dispute concerning the interpretation or application of UNCLOS. And in the Chagos Marine Protected Area arbitration, Mauritius initiated proceedings against the United Kingdom and contested the legality of an establishment of a marine protected area for the entire EEZ of the Chagos Archipelago by the UK, which administers the islands. And in this case, Mauritius, taking the view that sovereignty over the islands belongs to it, initiated proceedings using the UNCLOS dispute settlement procedure and argued, among other points, that the UK had violated its rights as a coastal state in terms of Articles 255, 56, and 76 of UNCLOS. In response, the tribunal conducted a balancing exercise, considering that whether or not it had jurisdiction depended on whether the parties' dispute is primarily a matter of the interpretation and application of the term coastal state, with the issue of sovereignty forming one aspect of a larger question, or whether the parties' dispute primarily concerns sovereignty with the UK's actions as a coastal state merely representing a manifestation of a dispute. And based on this approach, questions concerning the exercise of enforcement powers in the territorial sea seems too directly connected to the question of sovereignty for a tribunal to have jurisdiction under the UNCLOS dispute settlement mechanism. However, if a tribunal could be persuaded that an issue is more of a dispute concerning UNCLOS, there is a possibility, perhaps, of taking a case to an international tribunal using Part 15 of UNCLOS. The third and the final issue is a possible role for international tribunals in the larger context of the East China Sea dispute. The very root of the tension in the East China Sea is the fact that coastal states have not been able to agree on the method of delimitation and the location of the maritime boundary. On this fundamental issue, the role for an international tribunal is quite limited, and as we have heard in the earlier presentations, due to China's optional declaration under Article 298 of UNCLOS, which allows it to exclude disputes concerning the interpretation or application of Articles 1574 and 83 relating to sea boundary delimitation from the scope of UNCLOS dispute settlement procedure. And this Article 298, paragraph 1, A1 further provides for a conciliation procedure, but the possibility for such a procedure may be limited in the East China Sea if the parties cannot agree to set aside disputes or any issues concerning the sovereignty over the islands. But pending delimitation, coastal states have entered into interim agreements on various issues, and this was also highlighted in the previous presentation. And so we do have a number of interim agreements on fisheries. We have a prior notification regime of marine scientific research. We had a principal consensus on the mineral resources joint development in 2008. So we have been trying to create legal frameworks that would govern the activities in the undelimited area. Nevertheless, the unilateral activities in the East China Sea had led to certain frictions, led to certain incidents. And under Articles 74.3 and 83.3 UNCLOS, this provision includes an obligation not to jeopardize or hamper the reaching of the final agreement pending delimitation. And this provides sort of guidance as a matter of law as to how the coastal states should act in the undelimited area. However, this obligation is stated in very general terms, and it may not be always easy to draw specific guidance on particular activities, even if we take into account a relevant jurisprudence. And in this context, a ruling from an international tribunal that provides specific guidance on the matter may be helpful in managing the situation in the East China Sea. However, this was also discussed by Professor Zhang. For one party to unilaterally initiate proceedings on this matter using the UNCLOS dispute settlement mechanism, for that to happen, the dispute must be considered outside the scope of the exception under Article 298. So if you come back to the text of that article, it says that it allows states to declare that it does not accept compulsory dispute settlement under UNCLOS for a certain category of disputes, and one category is disputes concerning the interpretation or application of Articles 1574 and 83 relating to sea boundary delimitation. And one very simple way of reading this provision is that the optional exception also applies to the obligation under Article 74.3 and 83.3, the obligation not to jeopardize or hamper, since the disputes concerning Article 74 and 83 obviously includes those relating to its paragraph 3. So this is sort of a textual, one way of interpreting the provision. A similar reasoning was adopted by the Conciliation Commission in the Timor-Leste case versus Australia case in its decisions on the merits. However, I think the article can be read in another way, and the terms relating to sea boundary delimitation can be interpreted not simply as a description of Articles 1574 and 83, but also as qualifying those disputes and limiting the exception to a subcategory. And in terms of the text, this reading may appear to be more natural since it gives meaning to the inclusion of the word, very specific words relating to sea boundary delimitation. This is in accordance with the principle of effectiveness. And in addition, considering that the rationale of this exclusion was to exclude disputes relating to important and politically sensitive issues, disputes concerning Article 74.3, the obligation not to jeopardize or hamper, seem to be different in nature from the maritime boundary delimitation disputes. So for these reasons, there may be room, even after the decision by the Conciliation Commission, to argue that an arbitral tribunal could have jurisdiction under the UNCLOS dispute settlement mechanism, where the party has made a declaration under Article 298. So to wrap up, I do not see any role for international courts on the question of sovereignty over the Senkaku Diaoyu Islands. However, there may be certain limited ways to bring a case to an international tribunal using the UNCLOS dispute settlement mechanism. And a decision from an international tribunal may contribute to the situation by clarifying the law under which states involved are expected to operate. Thank you very much.
Well, thank you very much for that. That was excellent. One of the things, and I look forward to your questions while you're formulating them. I'm going to ask the first question here, and one of the things I was surprised, frankly, that I didn't hear from any of the panelists had to do with something other than arbitration or litigation. There are such a range of internationally facilitated dispute resolution processes. One of which, for instance, came up earlier today, which was, for instance, a court of inquiry to do a factual determination. Also, advisory opinions that can be solicited. And I'm wondering I'm wondering whether any of you think that clarifying either the law or the facts of the circumstances might be a worthwhile endeavor concerning the sovereignty dispute over, and yes, I'll use that word dispute here, over the Senkaku Diaoyu Islands. And so, in particular, there's, from the Chinese side, for instance, there's questions as to just exactly how the islands were incorporated by Japan's cabinet decision in January of 1895. By the same token, there's plenty of factual questions to be asked about why first the ROC in 1945 to 49, and then the PRC from 1949 to 1970. We really heard no clear articulation that the islands belonged to China when actually the war had been ended, and so there's a host of factual questions that could be addressed, for instance, there, and clarifying the law, it seems, as to exactly, for instance, what is the critical date in this case? How should we consider the application of law in the context of the critical date? And so I'm wondering what the panelists might think about that particular approach as not a dispute resolution, but at least as Henry Benserto was talking about earlier, an opportunity to narrow the scope of the dispute and to clarify some of the issues for the parties to more effectively come to a resolution on their own. And I'll ask each of the panelists to make a contribution on that, starting with Shin-Jun.
Well, I think that a court tribunal, the major function is to settle the dispute rather than find what is the correct and law or fact. And also, I think that the judicial function of a court tribunal is so entrusted by parties. I think even you go for a tribunal or a court asking for determination of fact, you still need to have the consent of the parties. I think that this kind of, the narrowing certain, or just taking certain aspects and then leave the others and decide it whether it's appropriate in terms of judicial function of that specific tribunal or court.
Kentaro, what are your thoughts?
Yeah, I think your question raises a very important issue, and I think this is also connected to the Japan's position of no dispute over Senkaku Diaoyu Islands. So I would like to just go into that also. And one of the reasons is that the claims by China have not been really specifically articulated or not communicated to the Japanese government, and there also has not been any formal rebuttal of those positions, and I think that has some relevance in understanding Japan's position that there exists no dispute over the islands. And the situation is quite different from...
I'm sorry, clarify, no formal rebuttal to what?
Well, there has been no very detailed explanation of the Chinese claim over the so-called, what they call Diaoyu Islands. And so let me explain. So the situation is quite different, for example, from the Takeshima Dokdo Islands dispute.
Yeah.
Because in that case, there has been several rounds of no revals, each side clearly formulating their claims in regard to what is disputed. So we have a clear understanding of what is the formal position, what are the issues involved, what are supposed to be the basis, or what are supposed to be the very documents that each parties placed their grounds on in making those kind of arguments. And I think with respect to the Senkaku Islands, the interactions between Japan and China has not gone into that detail, at least yet. And that is sort of the background to the Japanese position that there is no dispute over the Senkaku Islands. So I think it would help to have that kind of clarification, or I think you referred to that as narrowing down the issues. And so I think that would help. Well, practically, the formal Japanese position that there exists no sovereignty may get into the way, but I think it's good to have sort of fact-finding, clarifying the issues involved, if it's not possible in a formal manner. I think Professor Son proposed maybe having like a joint sort of fact-finding or discussing the issues using maybe a track 2 or by an expert panel, and I think that those would help. But one probably caveat would be that I think in terms of the facts, I think at an academic level, I think the issues are fairly clear, and I think the experts on both sides are well aware of what the key documents are, but I think there's a lot of difference on how those documents should be interpreted, and that might not be a sort of a thing that could be resolved through a fact-finding sort of process. That might be an issue of how to interpret those documents. That might be a little bit different from any role that fact-finding can play in settlement of a dispute.
Well, all right, I'll leave it there. Go ahead. Song?
Thank you. If we look at those options to settle disputes by peaceful means, inquiries is one of them. In the past, we have the practice under the 1907, the Hague Convention, the Commission of Inquiries. Now, Peter, you mentioned about a factual determination. But what if both parties really submit the disputes to the tribunal? In that case, I'm not going to let you know I have certain evidence in my favor. If we look at the case between Singapore and Malaysia, during the proceedings, so some sort of useful historic records were not disclosed to the other party. So which means that when we have that kind of expert group of legal historians to study those historical evidence, and then that will, again, have some impact on the willingness to submit the dispute to international tribunal or court. That's one thing. The second one is about critical date. And I read the case between Malaysia and Singapore regarding the critical dates in 1979. The government of Malaysia issued the map, including the territorial sovereignty over those islands, especially so-called White Rock, Pendra Branca. And then after that, in 1980, the government of Singapore began to protest. And that's the critical date for that dispute in 1980. And then in 1993, because the government of Singapore raised the issue regarding sovereignty disputes, Middle Rock and the other one. So that's the critical date. What about in the Senkaku Diaoyutai dispute? I don't know what about your position. Are we talking about January 14, 1895? What about the 1951, 1952, the San Francisco Peace Treaty, or the treaty between ROC government and Japan to return those islands to the government of Chinese government? What about the Japanese government position that 1971, when the United Nations have that kind of a report indicating oil resources, and that's the beginning of China and Taiwan to raise the disputes and so on. And there are other issues that protests, acquisitions, silence of the government. So it's very, very complicated. I'm not sure that we are able to deal with those such complicated issues. Final point is the role played by the third countries. The United States Trump administration, Obama administration, both say that the U.S. government is willing to play the role as the mediator in the South China Sea. When Trump went to I think Hanoi, he made that suggestion, but that was objected, right? And then I think former Secretary Hillary Clinton also mentioned the possibility for U.S. to play the role. But unlikely for China, maybe Xinjing, you know better than me, is not going to accept that kind of role played by the United States. But what about other European countries? Are there any possibility ASEAN? So maybe that's the thing. Peter, I think, let me stop here. Yeah.
Okay, terrific.
Okay, thank you very much. The couple of the comments I'd like to add. For example, if there is a dispute and if one of the parties want to make a lawsuit against the counterpart, I believe that from the legal point of view, door is wide open, so that if the one-state parties want to initiate it from the perspective of the dispute settlements in legal way, I think they can do the whatever measures they can choose. But the reason why, in conjunction with the morning session, the attitude of the Asian states in terms of the rely on the dispute settlements, I don't think the Asia, including Korea, is pessimistic or the negative to use the third-party adjudication. Because when you think about the cases and when you think about gravity of the cases, and when you think about the national interest, the cases involved, if you or your states believe that it is better to go to court, I believe that definitely we go to court. But thinking about the cases we have in these days, in particular, for example, the Senkaku or Diayuta issues, I can't see that any reasons for Japan to go to court for these cases. Likewise, Korea has no reason so far to go to court in terms of the issues we have with Japan. And so there is a pros cons whether we use the third-party adjudication in terms of the settlement, and that is not necessarily mean that the Asian way of the dispute settlement mechanism is negative or the pessimistic. But as I mentioned in my presentation, there is a very good way in Asia, in particular in Korea. We are very much try to adopt the decision-making or the judgment of the tribunal as far as we can accommodate. For example, in particular, in terms of the protection, preservation of marine environment, which is a very important issue, and also the try to reduce the level of the law enforcement against the illegal fishing activities in our area. So that those are significant developments I can find out. And since the dialogue we have here from the podium, in particular how we approach these issues, do you see that the gravity of the discussions go to sovereignty issues directly? So if we maintain in this way, it's hardly difficult to resolve these issues. And back to the issues of the San Francisco Peace Treaty or the critical date, the reason I mentioned too is that this is sovereignty issues. And when you're talking about the sovereignty issues, you have to think about what is the state parties. And non-renunciation, exactly the same with the editor Yemen of the Article 16 of the Treaty of Lausanne, which has the give a right to third party. And so that they think about the blanket renunciation of the San Francisco Peace Treaty in terms of Senkaku or Diayutai. And then when you think about the sovereignty issues, the issues should return to originally back to the where that issues came from. I personally believe the critical date should be the 1894 or 5, actually the Shimonoseki Treaty. At the time where those features are belonging to is pretty much important to figure out. So that's one of the reasons I mentioned today.
Well, thank you very much, Jerry.
Thank you very much. This has been a long, difficult discussion. To discuss such detailed questions in short-term oral communication is a huge challenge. So I hope we will be able to publish on our U.S. Asia Law Institute website your individual presentations, because each of them is really worthy of serious study. We can't possibly assimilate all these arguments sitting here in a short compass. Second, I think Professor Nishimoto is quite right. I think we all recognize it's unlikely that adjudication is going to be looked to solve the sovereignty dispute in the East China Sea. In those circumstances, I think Japan should seriously consider a better public rationale for why it refuses to recognize there's a dispute. And the next question would be, what are the implications if it did recognize there's a dispute? To the public, it looks absurd to say there's no dispute over the Senkaku. Everybody knows there's a dispute. And to the layman, it just looks silly. Now, when we look at two other leading island territorial sovereignty disputes, we see in Korea, as we've heard, the unwillingness of the Republic of Korea to respond to Japan's challenge. Japan wants to go to the ICJ on this. And we've heard an answer. Korea doesn't just say there's no dispute, as far as I understand, but I'm not sure I understand what its defense is. Then we look to the Paracels and the Vietnamese dispute with China over the Paracels. As I understand the Chinese position, it's we negotiate territorial disputes, we don't use other methods. But the Vietnamese tell me every time they ask to discuss the territorial sovereignty question of the Paracels, the Chinese refuse to negotiate, even though they say their position is, of course, we negotiate. I don't know if that's accurate or not, but we have three serious island territorial disputes. The occupier, for one reason or another, refuses to go to any available third-party dispute resolution mechanism. So it's a strange situation in Asia, and I personally would like to see Japan come up with a different rationale. Now, they could say what China says. We don't use third-party adjudication for territorial disputes, but then they wouldn't be able to try to sue over Tokto. So they have to be careful what rationale they select. So this is a strange situation. I'd love to hear Taiwan's view on these three disputes also. My final point is on the merits of the dispute. If there ever comes a time when the Senkaku Diaoyu dispute can go to some impartial decision maker, I'm curious about the critical date was raised, January 14th, 1895. Somebody should tell people what that's about. Was that the declaration by the Japanese government that they were annexing these islands, the Senkaku, because they were territorially unclaimed, terra nullius? Why then did they keep it secret until 1943? Or is that not the fact? It seems from the evidence that was dug up by the young man from Taiwan I used to know, I think he works for Microsoft, he dug up evidence to show the reason the Japanese government kept their declaration of annexation secret was they didn't want China to know because they thought China had an interest and would be offended by it. Now, maybe there's insufficient evidence of Chinese claims to those islands, but that's a pretty interesting factual situation. Can you infer a Chinese expressed interest in those islands because of the Japanese secret declaration over those islands? This is a great case.
It is. Sharon, did you have a question?
I don't know if you want to just go to let people comment on Jerry's questions, because I might derail that
I'd like to
flow.
get your question too, and then we'll go once through the panel.
It's more of a comment. Is that okay?
Nope, it's fine.
Okay, so I want to thank the last three panels and the last two in particular for very dense presentations that were just so informative. And the observations I wanted to share is, in some ways, to close the circle of the day. So we began with looking at international law in a specific area, in the area of human rights law. And we now have been looking in the last three panels on international law in the area of particularly law of the seas and related law and regulations. And it might seem like apples and oranges, but to this tired brain, it feels like there's something about all of this discussion today that's all about fruit. And some of that fruit is hybrid fruit, because some of the issues that each of you have touched on in the last panel actually involve hybrid issues, which we have not talked about as hybrid. For example, environmental justice, access to resources, hydrocarbons. A lot of these issues are crossover issues. So they're not viewed as that, but I'm simply saying they could be. So the thought experiment that hit me that maybe could be an interesting part of some of the work that all of us are doing is that on the jurisprudence, there really are, and we didn't talk, what if we had had this conversation this morning and talked about the jurisprudence of international human rights law like the way we're now talking about law of the seas? That conversation would be radically different. It would sound more like this. The jurisprudence is developed with declarations and with reservations. It is a consent-based system that's treaty-based human rights law. Yet some of it is not consent-based. It's compulsory. That's the charter and some of the customary law. But treaty-based law, reservations in human rights law, there are limits. You can't make any declarations you want. You can't reserve to everything you want. And that there's a procedure for other states to say, you know, the reservation that China or one of the Latin American countries entered, we think it guts the spirit and the letter of that reservation. So they can actually start a procedure to challenge your reservation or your declaration, which are different in law. So that's one. The second thing is on the jurisprudence is, I'll leave that for a minute, yeah. ICJ, almost every single human rights treaty has a reservation to ICJ jurisdiction. So they've already cut off at the map the kind of international tribunals human rights disputes will go to. I think we can think about that. Then I was very taken by the comments on his history and context and disputes going back to 1895 and older. So we think about Tibet, Xinjiang, Hong Kong, Taiwan in the context of sovereignty issues and historical claims and boundaries. I was quite shocked in talking about Xinjiang that in fact I saw maps recently that go back to turn of the century, 1920s, where Xinjiang or historical Tibet doesn't look like what it looks like now and what China's claiming. So all of that's only to say, thank you so much, because it really got me into a very interesting thought experiment. But I do think it's valuable because I think if we cross out of the doctrinal categories of international law, there are ways in which these different doctrinal practice, because you're all practitioners and theorists and researchers, some thinking crossing over those doctrinal international law boundaries, I think might be productive. It may not, but it might be interesting.
Thank you very much, Sharon. So I'd like to give each of my panelists 1 minute to make any final comments you'd like to make based on what we just heard. Is there anything? Absolutely. Okay, we'll go the opposite way. All right. Fair enough, Shoku. You're up. Go ahead.
Should I go first?
Hey, sure, yes. Any last minute comments?
Right.
Good job.
I have one example to share is that although we are talking about a little bit bilateral issues, but there is some area in East China Sea. There are three overlapping areas where the three states, like Korea, China, Japan, also Taiwan, is their jurisdiction overlapping because there are three fisheries agreements and also plus the Taiwan to Japan's fisheries agreements. And so that there is a highly sensitive, the overlapping area in terms of the jurisdiction. And the law enforcement agencies is very difficult to make a decision when they exercise. But there is a very good thing is that there is no serious reports in terms of skirmishes and the conflicts in that area, because the state parties in the region is a refrain from exercising the sovereign right against the other state fishing vessels very hard. So that before we solve the issues, I believe that this is very much important for state parties to limit, exercise their sovereign rights against other state parties, which might be jeopardize the current level of the maintaining peaceful relations among the state parties.
Regarding the January 14, 1895, because the Japanese cabinet made the decision to incorporate the island, Senkaku Island. But at that time, because the war between China and Japan was about to finish, and Japan realized it's going to win the war. So, and then at that time, so the January 14, 1894, what is the critical day at that time? But later on, the name issues, because maybe the Qing government did not realize that name is the name for Diaoyitai. So there are other issues. And there are other correspondence, historic records, maybe we don't know. I think it's very important for legal historians. You mentioned Sao Hanyi. He did serious study and he went to Japanese libraries and so on. But that's what I'm suggesting, that good or bad, that you have a study group to invite legal historians to conduct a serious study, but at the same time that will affect the litigation later on. The second point is about the question, Law of the Sea Convention is a product compromise, is a package deal. At that time, regarding Part 15, the mandatory settlement of disputes, it's very important to have Article 298, mainly because compromise. That's allowed to have the option to opt out. If we look at the Article 121, Article maybe 58, it's the same thing. Ambiguities are allowed to compromise. Now, if we look at the interpretation of application of those Article 121, what Japanese
So
government
we have to
finish.
yeah.
Japanese government's position regarding Okino Torishima. That rock, even we have the Japanese scholars recognize it's a rock. But how can the Japanese government interpret that rock can generate 200 nautical miles? Is it? Again, sovereignty, national interests. So when we try to look at the convention, that's the basic concept, very important. Thank you.
In terms of no dispute being the official position of the Japanese government, I think this pattern is not limited to Northeast Asian states. I think we have a consistent pattern of states taking the position that there is no dispute when they have effective control over a piece of territory which is challenged by other states. So you might find that position silly, but I think even if it was silly, I think it's some silly thing that states do in this kind of situation. And also, I think you have to realize that, so I mentioned in my presentation, this is intertwined with the merits of the case. And this is a shorthand for saying that we are so convinced about our position that we're not willing to recognize an equally valid claim from another state. So this is not sort of a plea in the jurisdiction case before an international court. This is intertwined with the merits, and it's just saying that we are so convinced with our position that we are not recognizing another claim as perhaps equally valid. But then I get your point, and if that is really the case, I think more efforts should be made to have exchanges with that other party if you're so convinced about your case. So I think there should be more efforts in that regard.
Thank you.
No, I think that in between Japan and China, the priority in East China Sea, I count two types of dispute that we have to face. The territory dispute, Senkaku Diaoyu, and then the delimitation related disputes. The other disputes, law enforcement, environment is okay. We can live it even we settle the other disputes, this kind of dispute may come up again. So the priority is to kind of, for the territorial dispute, I think if you consider the Chinese rationale regarding the principle of consent on the jurisdiction of the court or tribunal, you'll find it is very hard for China to unilaterally raise this dispute against Japan. So when Japan saying that there's no dispute, but okay, we wait for you to submit this case, that is, it comes with nothing. So I therefore put a question mark on the special agreement. The only possibility is to get a special agreement to submit to a court tribunal. This is a possibility. But that possibility relies much on the political will. But for the possibility to be true, at least Japan should recognize this dispute. This is the first step for a special agreement. For the other two delimitation related, I think that's important to divide in two areas, S1 and S2. Those pure delimitation dispute and those delimitation dispute necessarily involved sovereignty dispute. Well, under the UNCLOS, as China, made the declaration under Article 298, then China have to accept the submission of delimitation dispute to a compulsory conciliation commission. So it is possible for Japan to submit the pure delimitation related dispute to a compulsory conciliation commission, but not those necessary in the southern part of the East China Sea. But to these pre-delimitation disputes regarding the obligation not to hamper or jeopardize the reaching of final delimitation, that kind of dispute, I think, as far as we hold the Estimo Australia case decision on competence is valid, I think it's very hard for the Japanese government to submit that issue to adjudication or arbitration. The only way is to submit it to compulsory conciliation. But at that time, you will think about to make what sense to submit to a compulsory conciliation commission for a recommending report on possibly alleged violation of Article 83, Paragraph 3.
All right, thank you very much. Before we thank our panelists formally, Jerry asked me to say just a couple of words, and I do mean a couple, about that essentially sum up what we've heard today. I think Sharon actually did a great job starting that off, and there are two things that I want to say. Both of them, frankly, are optimistic. And the first has to do with what Xinjun just said, which is the idea that international law evolves because of political will. And we make accomplishments because of political will. And things that might seem intractable eventually somehow untangle. That's what the history of the cases that we've been talking about today really is all about. Parties eventually got to yes. And they showed up, and they came to a conclusion, and they resolved the disputes. And we have to remember that, actually, because each one of the disputes that ended up becoming litigated was started out as an intractable dispute. And what we must keep in mind is that international law exists to avoid conflict. If we want to connect the two, the dispute resolution and our human rights, I think the international law is evidence of progress of human society. And because the least way to honor human dignity is to kill a person, right? To kill a person over some of these disputes. And the relationship between human rights and some of these issues, I think Sharon has pointed out, is a very important one. So getting to yes, that's how I described it in my presentation. I think there are pathways to getting there, and we can't let the moment mire us in despair that we can ever, in fact, move forward effectively to a resolution. The second thing I'd like to say is that each of these issues, be it human rights or be it progress on dispute resolution, I see a common thread of incrementalism, that ultimately small victories accumulate. I think we need to bear that in mind too. Bear that in mind as well, because small victories accumulating over time become big victories, and that's how we get to yes, and that's how we resolve disputes. That's human progress. So I think there really are ways in which we don't have to get to the ultimate question to begin with, but there are incremental approaches that get us closer to the capacity for each side to look each other in the eye and say, it's better to resolve this dispute than to kill each other. So with that honest assessment and truly optimistic assessment about what international law can do to help us to resolve these disputes in ways that avoid conflict in very tense areas. I think this contribution that the Jalat Dialogue has done is something tremendous. So in addition to thanking the panelists, I hope you'll thank Jerry for a great program.